Hello and welcome to episode 8 of Fire Away, Rudner Law's online Q&A show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator and the host of Fire Away. Reminder that Fire Away streams live online every month on Facebook and on YouTube and of course on our website. If you have any questions and you're watching live, we'd be happy to answer them. You can always comment on the Facebook feed, on the YouTube feed, or tweet your questions to @RudnerLaw. As usual, we have a guest today, and it's a bit of a surprise guest. We were supposed to have Stephen Degajnik, but unfortunately he canceled at the last minute. But we are very fortunate to have Omar Ha-Redeye with us this morning, or this afternoon, I should say. Omar's been on the show before. He is a Toronto lawyer. As I probably said last time, he wears many hats, and he's now got one more. He's now the executive director of the Durham Community Legal Clinic. So, Omar, thank you for parachuting in on a couple of hours' notice, and really appreciate you being here.
My pleasure. Thank you for having me, Stuart. It's always great to have these conversations.
I think this should be a good one. And so the plan for today is we're going to talk about dismissals because the reality is that although our firm practices employment law, we work with employers and employees on all different aspects of employment law. But if I had to pick one most common issue that people come to see us about, it's termination. And the reality is there are many myths and misconceptions out there, and people often make uninformed decisions. So I want to talk about the law of dismissal. I want to talk a bit about the typical misconceptions that Omar and I see in our practices, talk a bit about how the law actually works, and I'm looking forward to this part of the post. Talk about how the law should work, because there are lots of criticisms about the way the law stands today. So when I get my turn to fire away at the end of the show, I'm going to talk about what I've put together as the top 10 most common mistakes that people make after they've been let go, or phrased another way, the top 10 things that you should never do after you've been let go. So that'll be later on, but first I want to bring Omar into the conversation. So I think it's the biggest myth out there, which is that if you're let go and there isn't cause for dismissal, you get severance of 1 month per year. And even though our courts have said over and over and over again that's not how it works, I hear it from almost everybody that comes into this boardroom. Omar, what are the common myths or misconceptions that you encounter?
Yeah, I mean, I think the amount of notice is definitely one of those things where people use a shorthand. I think that's where it comes from, especially if they don't have a legal background. There's a debate about whether or not the 24-month notice is a cap or isn't a cap. You actually have case law going both directions, and I think that's probably not going to be conclusively determined any time in the near future, perhaps the next few years, until the Supreme Court of Canada weighs on that definitively. So I'm not as perhaps as dismissive as those myths. I think for the vast majority of employees and the vast majority of employers who are hiring those employees, those rule of thumbs, which may not be precise in law, probably gives them an idea or a rough estimation about what entitlements might be, and allows them to be able to proceed, hopefully without the most amount of conflict or litigation in a way that's reasonable, may not be 100% of an employee's entitlement, but is reasonable and allows both parties to move forward without actually ending up in an acrimonious situation.
Yeah, I mean, I agree with you there. And the last thing most people want is to go to court. Other than lawyers, nobody wants to go to court over these things. And in most cases, it's probably not worthwhile. And I tend to say the same thing to clients that you just said, which is the rule of thumb, a month per year, for example. It's a good starting point. What worries me is the people who go by that and really shortchange themselves, or from the employer perspective, expose themselves to a lot of liability. So, for example, the senior executive who's lured away from a 15-year job and is let go 3 months later, and the president says, oh, well, he was only here 3 months, so I'll give him a couple of months and he'll be happy. And realistically, he might be entitled to a year or more of severance. There's lots of other scenarios, but it gets back to one of the points I will make when I get a chance to fire away, which is it's almost always worthwhile, at least in my view, to see an employment lawyer to make sure that your rights are being respected, because there are a lot of employers who, sometimes it's intentional, but in many cases it's unintentional. They make the same assumptions that everybody else does about a month per year, and they shortchange the terminated employee. And now you've got someone who's just lost their livelihood, and they are leaving, in some cases, substantial amounts of money on the table. The other thing that I see a lot now, and this is sort of the reverse in a way, people think they're entitled to more. People are often think that they have been treated badly because they're being told they have to work through the notice period. And so one of the common misconceptions out there is that you're entitled to a package. Do you see that often as well?
Certainly, yeah. I mean, I think even beyond that, the terminology that we use in law, such as wrongful dismissal, itself attracts a lot of attention. And so people feel as if they're in a job and they've been told, okay, you're being dismissed, and so without cause dismissals, we're not actually saying you've done anything wrong, there's not any performance issues. They still feel wronged in some way, even if they're being provided an adequate amount of notice. And so there is some misunderstandings there that we assist as well. Part of what my concern is, though, and I think this is what we're going to get to when we talk a little bit about law reform, is that although I agree with you, Stuart, it's very, very employees to involve lawyers in that process, is that this process is perhaps unnecessarily complicated, could be simplified. In fact, the laws that govern every single one of us in the workplace could probably be better navigated without as extensive legal involvement. For the special cases like the ones you referred to, where there are executive positions and very large salaries and more complex facts, we certainly do want to have lawyers involved. And I think it's in those types of facts that it would justify having the amount of expenses involved with having lawyers being involved in those cases. But again, for the vast majority of people in Ontario, that's not the circumstance that they're dealing with in the workplace. And I think our employment law regime should perhaps reflect that better.
Yeah, and I think that's well said, and I know we're going to get to that. And I think you're right. I mean, for the vast majority of people, and I guess the distinction might be partially this. I encourage everyone to have a lawyer review a severance package. I'm not encouraging them to retain counsel, to actively negotiate on their behalf and litigate if necessary, and incur tens of thousands of dollars. I'm talking about at the very least that one meeting to review it and tell the person, yeah, everything looks relatively reasonable, or no, you really need to push back more. And I'll tell you, we do a lot of consultations in this office, and I've done it in my previous firms. The vast majority of cases I have said, look, this package isn't quite what it should be. But then there are many cases where I'll say, but you know what, the difference is not enough to warrant retaining us to represent you. So you might want to go back and try on your own. Or even in those cases where I say, you know what, I've reviewed it, and it is a very fair and reasonable package. I've never had anyone say they regretted coming to see us. They've always said, at least it gives them peace of mind that they're not leaving money on the table. So I agree with you. I think the problem is that people assume if they go to a lawyer, they're sort of opening the door to massive legal fees, whereas it could be a one-time meeting and that they can be comfortable that they're not giving up their rights. The other point I was going to come back to, which is interesting, is I often, and I'm sure you probably see this as well, you go to a social event, a wedding, a cocktail party, whatever, and as soon as people find out what you do, and especially in my case where I say I do employment law, they've all got their stories. And it's often the case where someone says, oh, I was let go of my job 6 months ago, but I took care of everything myself and negotiated myself a great deal, and I'm glad I didn't waste money on a lawyer. And I usually try not to prolong that conversation, but sometimes they want to share the details with me, and it's amazing how often they don't realize how badly they shortchange themselves. Like the person, this is a true story, who was telling me that he was let go after 6 years of employment. You got 8 months severance, which was more than generous, and on its face that sounds pretty good, until he explained that he was a commissioned salesperson, and roughly 3/4 of his income was commission, and what he got was 8 months of base pay, which is really equivalent to a couple of months. So again, examples of where if he had gone to a lawyer, done a consultation, he would have known that, and he could have made an informed decision.
So I think I'll jump in there, Stuart, and I think the what you're referring to here is not just the notice period, it's about how you calculate what the monetary amount would be. And I think that is where often lawyers can be far more useful. The notice period itself is something that's more philosophical, it's not a hard science, it's a little bit of an art. People argue back and forth about it. But I think when you're talking about some of those complexities, especially around benefits, I think this is one of the areas where I see it a lot. looking at the amount of benefits and benefits continuing through a notice period, or at least having the equivalent monetary amount for benefits through a notice period is something that I often see people leaving on the table. But I'm going to go back and take a step back here in terms of what you referred to, is what we often call independent legal advice, that you don't need to retain a lawyer to start a lawsuit. That's a very common misconception. And so for a relatively reasonable amount, I don't know what your office charges, but coming from private practice, depending on the complexity of the situation, the amount of financial documents I may have to review, this can very easily be done, I think, usually between $1,000 to $2,000 thereabouts. And so you can actually get legal advice looking at a package, have a lawyer say, you know what, it's within 10, 20% of what I would estimate, and so it may not be worthwhile to initiate a lawsuit because you're going to have legal fees and a delay in that money. That's actually very important to keep in mind. A delay in the money in your pocket by initiating this process. I'll do a small plug here in the legal clinic system. So I'm in a community legal clinic here. We provide those services for free to the public if you meet our financial eligibility criteria. And so for individuals who are going through that type of thing, it's often a short visit. You can have a conversation, knowing whether or not something is worth pursuing and the pros and cons of doing that.
Yeah, no, great point. And to be honest, I mean, we've got a great team here, and in many cases, we'll look at someone who wants to come in and we'll say, you know what, it's just not worth meeting with me at my hourly rate. We have some great juniors, and they can do that initial consultation for well under $1,000, in some cases under $500. So to me, in my mind, it's money well spent. And I get it. It's hard when you've just lost your job to talk about spending even $500, but as I often say to people, if it means you might be losing out on $10,000, I think it's money well spent. So, or as Omar said, if you qualify, go to the legal clinic and make sure you have someone who specializes in employment law, and they'll give you the advice you need and the peace of mind, like we talked about. So I wanted to come back to another point. We've talked a bit about systems and how you assess notice, and you made a great point, and it sounded like you were reading my playbook, actually. Most of my consultations, at some point I will say, everyone talks about how many months you got, the notice period, but nobody focuses on what a month is worth. So to your point, it's not just salary. By default at law, you're entitled to all the compensation, all benefits. It's salary, it's commissions, it's bonus, it's medical, dental, or the most common issue, and you can disagree or tell me if you disagree, disability benefits. Because this is the one, it fascinates me, because the law has always said that by default, all benefits must continue. And yet for decades, long before either of us were practicing, for decades, insurance companies absolutely refused to cover anybody for disability if they were no longer actively employed. And what baffles me, no one challenged this. It was only a case involving, the woman's last name was Egan, and the company was Alcatel. And it's probably about 2 decades ago now, where this woman who was in the middle of negotiating a severance package hadn't signed a release. She became disabled, called the insurer. They said, sorry, you're no longer employed, so you're not covered. So she sued Alcatel. And that one went to trial. And of course, as we both know, the vast majority of claims settle long before trial. But that one went to trial. And Alcatel's defense at trial essentially was not our fault. The insurer wouldn't cover her anymore. And what the judge said, and I'm paraphrasing, of course, was that's your problem. You had a legal obligation to continue that benefit. If the insurance company wouldn't, you had to find a way to make her whole. In that case, fortunately for everyone, she was only disabled temporarily. We've seen a number of cases since then that have confirmed that. And if the employer doesn't find a way to continue disability coverage, they step into the shoes of the insurer, and they can have a massive potential liability for if a person becomes disabled. All that being said, tell me what you're seeing, and sorry, I know I keep talking, but I will let you talk. I don't know what you're seeing, but I still see the vast majority of companies taking the same approach, saying we're not going to continue disability coverage beyond the Employment Standards Act period. And when you push them on it and explain the risk, some of them will offer some money. A lot of them just say, we get it, we'll take the risk.
Yeah, no, I agree with you, Stuart. It's an ongoing problem. I think one of the ways that I've resolved that in private practice, but also what we see in the clinic setting, is that some of those issues, especially where disability may have emerged prior to determination, is that we accompany the wrongful dismissal claim, or even consider a separate action on a basis of human rights, or at least contemplate it. And so in those conversations then with an employer, you can say, look, you have 10,000, 20,000, maybe more in damages beyond just notice, potential heads of damages. And that's part of it, is expanding the lawsuit beyond just notice can help employers recognize that there may be more at stake, and then they come to a table. And so I think part of it is once you identify that there are multiple areas of exposure, there's multiple ways to make a deal, if you will, then those conversations I think can often be more productive.
Yeah, no, I think that's a great point. And that's often something that we do as well. We'll expand the claim, or we'll threaten a claim for wrongful dismissal, for bad faith, for human rights, punitive damages, all linking back to some of these issues. What's the other point I wanted to make, though, because often people gloss over the wording in the severance package. And it will say something like, we will continue your benefits bracket aside from disability coverage for a period of X months. And people just skip right over that. And what's one of the points I always make sure to mention in the consultation is, look, what that means is that, God forbid, if you become disabled, you have no protection, no income replacement. So even though the insurance company may no longer cover you, the company should give you money to go out and get your own coverage. And what I then say is, look, if we can't negotiate that, then you should probably consider going out and getting your own coverage, because otherwise you have no safety net.
Yeah, I think one of the things that I will raise here in this context is an interesting case that came out of the Maritimes, I believe, and it was arbitrated. It was a unionized context where if you have a confidentiality clause or non-disparagement clause in the actually found as well that violation of those terms can result in the loss of those damages. And so, it's great. You have a deal, you've signed off on the deal, and everybody's happy. But then you go on Twitter, in this case, that's what it was, and you start talking about how you've been vindicated, you've achieved a great victory against your former employer, and the employer turns around and says, oh yeah, I mean, we signed this deal, but we're not going to now give you the money. The employee who does that may actually find themselves in a difficult situation, because courts have upheld those types of decisions by employers to not pay out money where those types of clauses have been violated. So I think it's important to keep in mind that the cooperative nature of a deal isn't just up until the point where both parties sign it. That deal has to be respected and followed even afterwards in order for everybody to be able to walk away in an amicable fashion.
Great point, and it kind of gets to one of the points I want to make when I get to Fireway later, which is one of the most common mistakes, is acting out of emotion. And usually by the time you get to that settlement, the emotions have settled down. But I still often get that question, well, if I sign this release, if I sign this settlement, does that mean I can't talk about this? And what I usually say is, yes, it does. And at this point, just forget about it, move on, and put it behind you. Because you're right, if they tweet or go on Facebook or even talk about it or write a book about, which we can talk about another time, then they may well lose what they and their lawyer have spent a lot of time negotiating. So I want to, I'm mindful of time, and I know you've got to run soon. So what I want to get to is, should the legal regime change? Before we talk about that, we should probably at least quickly explain what the regime is. So I'm going to take a quick stab at it, jump in, and you can input what I forget. But the long and short of it is, I often tell people this: if you're let go without cause, then you are entitled to notice or severance. And the question usually is, how do you assess what that entitlement is? How many weeks, how many months? And then you get to what you said before, what's a month worth. So you can start with the applicable legislation. In Ontario, it's the Employment Standards Act, 2000. If you're federally regulated, it's the Canada Labour Code. That will set out the absolute minimum amount of notice or severance you're entitled to. Then you've got the common law, which says everyone is entitled to, quote-unquote, reasonable notice. That's where people often say it's a month per year. And what the courts have said is they'll look at a number of factors, including length of service, of course, but also age, also the nature or the character of the position, the availability of similar employment, and anything else that's relevant, such as if you were lured away from previous employment. And you said it before, and again, at the trip of my script, it's very much an art, not a science. And if you were to go to court, which hopefully most will never have to, a lot of it depends on which judge you get. Some are very liberal, some are very conservative, some do think it's a month per year. But our job, of course, is to try to estimate what is most likely to happen if you go to court. That's the common law. Then you can contract out of the common law by having a termination clause in place. And as you well know, Omar, there have been probably 100 cases in the last 5 years where people have taken a run at the contract or the termination clause. Because what it can mean is a difference between 8 weeks of termination pay and 2 years of severance pay. So this can have huge ramifications. But that's the way the law works. And where it gets confusing is you've got the legislation, which people will look at, and maybe will say, oh, well, that's the law, so that's what I'm entitled to, or that's what I'll give. Then you've got the common law, this vague notion of reasonable notice. Then you've got the ability to contract out of the common law, which you may or may not do properly. And it leads to a whole lot of confusion, which has led to the suggestion that there must be a better way to do this. And I know we talked about this offline, that you have some ideas in that regard.
Yeah, so I mean, there may be a secret here about how I know a little bit about your script, Stuart. It's your book. So that may be the secret.
10 people have read it. Thank you.
We'll make it 11 by the end of the day. So the analogy I often use is that our legal system works on a rock, paper, scissors. So, we all know the rock, paper, scissors analogy. And so the statute will displace the common law. The common law is what the courts use, or judges use to interpret the common law, and the Constitution, which is a statute itself, trumps everything else. Okay, so there's almost a trifecta here of different powers. What makes employment law unique or different is that the contract that's involved here is directly involved in people's lives. So we have a 1987 case that talks about the importance of employment law in a person's life beyond just the fact that they're getting money from it. It's connected to their identity, to their livelihood, to their emotional well-being. So the law deals with this contract in a very different way than the other contracts we see generally in society. And I think all of those things are important to keep in mind. And so but it's a relatively small number of fraction of cases in employment law that are resolved on ESA notice. Like there's very few cases that are actually upheld on that basis. And so I think there is an opportunity, or there's room, if you will, for the legislature, we're in a democracy, to be able to modify or amend our legislative regime in a way that is constitutionally valid, but still minimizes the amount of conflict. And the way that we do that is provide greater certainty in the law. And I think generally in law, if we look at commercial relationships, employment relationships involved, both employers and employees would love to have greater certainty about what their entitlements would be. And so my quick solution, if you're willing to hear it, over here, Stuart, is that Section 57, which actually states the notice provisions in terms of what's reasonable notice, can be amended. Put 57.1, amend that entire provision, and say that it's no longer voluntary. You have a statutory provision that displaces the common law and actually spells out what a reasonable amount of notice would be. What this would do is allow the courts to have a certain amount of certainty. We throw Bardell out the window, more or less, and say, look, employers, this is how you can plan your payroll. You actually have a sense of what your risk might be. Employees, if you're going to be terminated, you also know what this is going to be. The one party who this would be probably horrible for, Stuart, I'm going to share this with you, is the lawyers, because 90%, if not more, of litigation is based on wrongful dismissal over disputes about Bardell factors and what that reasonable notice would be. But I think in light of the fact that this would be good for the public, I would be in support of it. It would be good for our economy as well, by extension.
So agree with everything you say, but as everyone always says, it deals with the details. So you changed legislation. What does legislation now say is required for a reasonable notice?
Well, and I think this is where it would still be subject to challenges. And so I think that the notice that we currently have in the ESA would probably be too short. But, Bardell might be too long. And so you would want to have something that is reasonable. There's lots of ways to do that. But codification, and that's really what this would be, codification to some extent of the common law is one of the ways that the common law legal system has tried to provide predictability, stability, and reduce the amount of friction and reduce the amount of time in courts. And so it's not as if we haven't done this before in our legal system. We just haven't focused on employment law and trying to reform that specific aspect of it. So I think, with adequate consultation and discussions with both employers, employees, and the employment law bar, I'm pretty confident that something could be developed. I would love to see a government take that challenge up and start to have that conversation.
Yeah, I mean, I'd love, and I've heard over the course of my career, I've heard a lot of people saying we've got to do exactly what you're saying, and it makes sense in theory. I've just never seen a model that works, because every model starts with some period of time based upon length of service. But then, of course, as we talked about, common law takes into account age, the nature of the position, the availability of similar work, implicitly geographic location. So there's got to be some reflection of those factors and others. Interestingly, and there's a whole other topic of discussion, there's some artificial intelligence solutions that are now appearing that will assess case law based upon 22 or 24 different factors that they claim are relevant. So this is where I think is the challenge. How does this codification take into account all those factors? It's never going to be perfect, but is it, instead of being a sort of a chart, it's almost like a more detailed table where you have ranges, so it could be 1 month or 1 year to 2 years of service, but then it also a table for, or column for age, or column for position. I just think it gets really complicated very quickly.
It can. I mean, the analogy that I would use is what we've seen in family law. And so we have child support and spousal support are two different aspects of support. With child support, it used to be governed by common law until the child support tables came into play. And they had a similar situation where there were multiple factors that were involved in calculating what reasonable child support would be. They simplified the whole process. Some people would have won with that simplification. Some people would have lost that simplification. The advantage was that disputes over child support were pretty much put to the wayside, because it's a matter of figuring out what income would be, and that would be a dispute. And then you look it up. To contrast with that is the Spousal Support Advisory Guidelines, which is not legislation. And so what this was an academic endeavor that effectively did what you described, Stuart, which is pull together a whole bunch of different factors. Today it would be with an artificial intelligence algorithm, and say, here are a bunch of ranges. And to this day, in family law, that's largely what is done. It goes into an algorithm and people come up with a range. And so I think, again, we have to be perhaps a little bit creative when we're looking at law reform initiatives, and look at successes. There have been critiques of those successes, but in the larger picture of things, it actually has benefited the public.
Yeah, no, look, I think something should be done, because the system now is just too much uncertainty. And I mean, I've got one of my favorite stories I've been telling for years. It goes back probably 15 years to when I was consulted by this lovely older Italian couple who owned a restaurant in Midtown Toronto, and they had grown tremendously. They took on some staff, and then the whims of the public changed, so they had to cut staff. And this older gentleman, I think he was probably in his 70s at the time, took the subway to U of T Law Library, found the Employment Standards Act, looked it up, flipped through it, said, oh, she's entitled to 2 weeks of notice. And as he said to me later, he even thought that seemed light. So he thought he'd be really generous and give her 3 weeks, which was probably more than he could afford, but he did that. And then lo and behold, about a month later, he got a really aggressive letter from her lawyer saying that she was entitled to months and months, and also bad faith damages and everything else. And that's when he came in to see me. And I had to explain to him that, yes, he did the right thing by looking at the act, but that's only one small part of the story. And I've had other people who've called the ministry, and they're only told about the Employment Standards Act. So right now the system doesn't work. And to your point about lots of time and money being wasted as to negotiating or litigating these points, I agree with you 100%. What should happen in many cases where there is no contract is the company should decide, we're going to let somebody go, we're going to go see our employment lawyer. Their employment lawyer will say, okay, I think it should be somewhere between 4 and 6 months. They'll offer the person 5 for the sake of argument. That person, if they follow my advice, will go see a lawyer, and their lawyer will say, it should be more like 7 or 8 months. And then they end up negotiating, and if they can't agree, litigating, and they're spending a whole lot of money on legal fees for no reason. My solution in the current regime is simply use contract. Have a contract with a clearly defined severance package, and it doesn't have to be onerous or oppressive. But as long as it's clear, then when the company decides to let them go, they'll say, okay, we agree to pay him 3 weeks per year, and they'll do that. And the individual should look at it and say, well, I agree to take 3 weeks per year. That should be the end of the story. So that's my solution in the current regime until we have legislative change.
Yeah, and as you know, those contractual provisions are very much under attack, but that has been the way that many of us in employment law have been trying to encourage employers to create that predictability and stability.
Yeah, I mean, I think that's a great solution if it's done right, because you're right, they're challenged probably more often than they're followed these days, but at some point we'll probably see some more stability there. Anyways, it is 1 o'clock, and I know you've got to run, Omar, so I thank you tremendously for jumping in the last minute, and I knew we'd have a great discussion. I'm not disappointed, and hopefully we'll have you back on again. As I said before, Omar wears a lot of hats, is tremendously active on social media. He's now the new executive director of the Durham, I'm going to get it wrong, Durham Legal Clinic.
Durham Community Legal Clinic.
Community Legal Clinic, thank you. Omar, where else can people find you?
You can find me on Twitter, Facebook, LinkedIn. I mean, if you send me an email, it's fine. If you're interested in the clinic system and if you're part of Durham region, we encourage you to come walk in. So we take walk-ins, and we're happy to see you here as well and have one of our staff have a conversation.
Excellent, and that's a great piece of information, because we do often have people call us, and when they find out what the cost might be to consult, even if it's one of our juniors, it doesn't make sense given their financial circumstances. But if they can come see someone like yourself or at your clinic, that's a great resource to have. So thanks again for joining me, and we'll catch up again soon.
It was my pleasure, Stuart. Thank you for having me.
Thanks. All right, Rob, I guess. All right, now I get my chance to fire away. And in season 2 of episode 8, or episode 8 of season 2 of Fire Away, I spoke with Omar Ha-Redeye, and we had a great discussion about the law of dismissal. And the reality is that at Rudner Law, we practice all aspects of law. We work with employers and employees. When individuals come and see us, they come and see us for a variety of things. It could be a contract offer, it could be harassment. But the vast majority of situations where someone comes to us for advice is where they've been let go. And in most of those cases, they've been given a severance package. In some cases, they didn't even get that. But the reality is we see people making so many mistakes. I've put together a top 10 list, or in true lawyer fashion, it's top 10 list and a couple of subpoints. Top 10 list, most common mistakes people make, or the top 10 things that you should not do after you've lost your job. So, number 1, and these are not really in any particular order. Number 1, sign the offer or the release clause. If you've just been told that you lost your job, you are in no shape to make a rational decision about the offer
here in like 10 minutes.
Secondly, unless you're an employment lawyer, you probably don't have all your rights and your obligations to make that decision. So it's a huge mistake to sign off. And if the company does what they never should do, which is to say you have to sign here if you want the package, that's even more reason not to. So take the package, listen to what they have to say, and then my advice is always go see a lawyer, have at least a consultation. And if you come see us here, then we'll either explain why the offer is insufficient, or we'll tell you that, you know what, it's not bad, and even if it could be made a little bit better, it may not be worth the cost of doing so. But as I said to Omar in season 2, episode 8, I've never had anybody say they regretted coming to see us. If anything, they got peace of mind of knowing that the offer they got was relatively reasonable. Otherwise, and I've had this discussion with many people who do come in, why would you sign off on something when someone basically calls you down to a boardroom and hands you a piece of paper? It's kind of like someone showing up at your doorstep and saying, we want to buy your house, here's the offer. You would never sign off on that. You take the time to research the market value, you talk to your friends, you talk to professionals, you have a lawyer read the contract, and then you probably negotiate back. And that's an important point to remember. When you get that severance package, that's an offer. That's not the end of the discussion. So you need to take that offer, assess it, get proper legal advice, and then decide what to do with it. The reason, though, that a lot of people accept the offer is because of what I'll call number 2 in my top 10, making assumptions. People often assume, and I've had people say this to me, that, I'm sure the company knows what they're doing. And what I always say to them in that case is, they probably do know what they're doing. And what they're doing is looking after their best interests, not yours. So there's a reason they made the package the way they did, and you should make sure that your rights are being protected before you sign anything. Other assumptions I hear, that's a common myth of 1 month of severance per year of service, which our courts have said over and over again is not the law. The courts will take into account things like your age, like your position, whether you're lured away from other employment, and anything else that's relevant. So there's a whole lot of factors beyond length of service. On the flip side, some people assume they have more rights. Some people assume that they are entitled to a package, when the reality is employers can let you go and give you working notice, in which case you have to continue coming to work, and of course they will continue paying you. That doesn't work in many cases. It's obviously got a lot of risks, but legally an employer is entitled to do that. And here's the mistake I see people make. They get all upset because they didn't get a package. They walk out. They've now effectively resigned and essentially given up any entitlement to severance that they have had. That's a huge mistake that we see far too often. Item number three on the top 10 list, believing that their contract of employment is enforceable. Because many termination packages start out by saying, in accordance with your employment agreement dated such and such, you are entitled to X. And the person will say, oh, well, I guess I signed it, so I'm stuck with it. And again, as Omar and I discussed in episode 8 of season 2, many contracts are not enforceable. There are dozens of cases across Canada over the last 5 years where people have challenged contracts, challenged termination clauses, and won. So don't assume that just because that's what your contract says, that's what you're stuck with. Again, that's where legal advice comes in. Item number 4, in terms of the top 10 mistakes people make when being let go, listening to their friends. Friends are great. Friends are great for support. Unless your friends are employment lawyers, then they shouldn't be giving you advice. But the reality is, they will tell you that, yeah, the law's a month per year. If you didn't get a month per year, you should get more. If you did get a month per year, then you're good. Don't waste your money on a lawyer. And then people walk away and leave lots of money on the table. Or they'll have their friends who tell them about the wonderful package that they got when they were let go of their job. And it's amazing the stories I hear of people who got 5 years of severance, when the reality in Canada is almost nobody gets more than 2. Or people were given, paid until age 65 when they retired, which almost never happens, especially when you're 43 at the time. And when people push back with their friends and say, well, give me the details, it's amazing how quickly the story changes. But people like to brag about the severance package that they got, and the person who just lost their job now assumes they should get something similar. We then waste a whole lot of time when they come to see us talking them down from that unreasonable level to what they should reasonably expect. Item number 5 in the top 10, firing off a really quick counter offer or demand. And this often follows that. So what happens is somebody gets an offer, let's say 4 months. They talk to their friends and say, oh, you really should be getting 6 months. They send an email to HR saying, I really should get 6 months, and that's what I want. And when HR then writes back and says, okay, they've now got a binding agreement. When the reality is they have no idea if 6 months is reasonable. It may have been 18 months, but they've now committed themselves to 6. And it really does not go over well when they then try to back off that deal. So before you make any offer, talk to the lawyer, make sure you get proper advice. Item number 6. Often when I explain to people how the duty to mitigate works, which means that if you're given a package, generally speaking, you have a duty to make reasonable efforts to find new work. And if you do, here's the key part. If you find new work, that will limit your entitlement to severance. So I might say that based upon the applicable factors, you're entitled to 8 months of severance. But if you find new work after 5 months at the same level of compensation, your entitlement is 5 months. So we often have people who are spiteful and say, well, okay, in that case, I'm not going to bother looking for work, which to me is an incredibly short-sighted decision. Because frankly, unless you're at the stage where you're going to retire, if there is a good opportunity out there, you should never turn it down because you want a couple of months more of severance from your former employer, even if you're not happy with them. So I see that happening often. Or item number 7, I guess the flip side, they do go out and get new work, but they try to hide it from their former employer. A, because they don't want their employer to cut off their severance, or B, because maybe they had a non-compete clause or non-solicitation clause, and they're worried their employer is going to find out. And I'll tell you, more often than not, your employer will find out. Especially, and I love seeing this happen when I'm acting as an employer, especially when you update your status on LinkedIn and everyone sees your new job. It's amazing how often I've sent letters to plaintiffs' counsel saying, your client's still claiming severance, but here's a copy of their LinkedIn profile. They've obviously mitigated their damage. So if you're going to find new work, there's no point in trying to hide it. You may as well be up front and negotiate the best package you can. And be happy with the fact that you found new work fairly quickly. In the long run, you're far better off. Where are we now? Item number 8, I mentioned this briefly earlier, acting out of emotion. We have an unwritten rule in our firm, which is that when someone calls us, and we often get calls from someone who is literally in their car on their way from the termination meeting, and they want to come in right now and see one of our lawyers. And we will do whatever we possibly can to put them on, because they are in no state of mind to talk about it. And usually after a couple of days, people calm down, but we still see people who are so angry and so vindictive because they were let go, even though it might be just a business decision, that they will refuse to take our advice, and they'll often ask for 5 years of severance, and we explain that you will never get that. Or they'll refuse to accept a very reasonable offer because they think they've been badly treated. So letting emotion rule is never a good idea when it comes to making what is really, at this point, a business decision. You've lost your job, you're not going to get it back. What's important now is making sure that you get everything you're entitled to, and that should be assessed objectively. Item number 8, which really falls on item number 9 falls on number 8, bad mouthing your former employer and burning bridges. It's amazing how often people want to go online on Twitter or Facebook or blog and bash their former boss, bash the former company. If you haven't signed any kind of a settlement yet, that's not going to make them inclined to settle with it. And in fact, they may pull whatever's offers on the table now. So you don't want to do that. And as we talked about again in season 2, episode 8, of Fire Away, if you have a deal, it almost undoubtedly includes confidentiality clause. Probably includes a non-disparagement clause. If you go online and bash your former bosses or talk about the settlement you got, you're probably going to lose whatever you signed off on. So it's just not worth it. At that point, you may as well just move on and put it in the past. And item number 10 in my top 10 is common mistakes of people make when they let go. This shouldn't come as a surprise to regular viewers. Not going to see an employment lawyer. The reality is that when you get a severance package, you are in a difficult situation. Your livelihood, you need to make sure that you're getting everything you're entitled to. And even though there's a cost involved in going to see a lawyer, it's almost always money well spent. And as I've said before, I'll say it again, I've never had anybody say to me that they regret it going to see us. Even if we said, look, the offer is actually quite good, at least they've got peace of mind. But the reality is that when we see people after the fact, in almost every case, they've left money on the table. They put themselves in a situation where they can't find money because they may, for example, have signed off on non-competition clause and assume the non-competition clause is enforceable. If it comes to see us, it probably isn't. But in the meantime, they've got minimal severance, and as far as they can tell, they can't work for a year and a half. So they've really put themselves in a very difficult financial situation, which impacts them and their families. So the worst thing you can do if you take nothing else out of this rant is not going to see an employment lawyer. And as we talked about it in Parkway, the cost of a consultation is not onerous. It's not thousands of dollars, but at the very least, you can come in, meet with myself or our team, and get that review, and it's a thorough review of the situation. We'll explain the law, and we'll make sure that you understand whether you should be pushing back, whether you should be doing it on your own or with a lawyer, or whether the package is fair, in which case you can have that peace of mind and you can move on. So that's my 2 cents worth, and you got it here for free. That's all the time we have for episode 8 of season 2 of Fire Away. I do want to again thank Omar. I owe you a tremendous debt of gratitude for jumping in at the last minute to join me today. We had a great discussion, and I look forward to the next one. Our next episode is going to be on October 15th, right after Thanksgiving, at least in Canada. And my guest will be Derek Hill of Hill Kinney Dental Practice Sales. We're talking about dental practices, obviously, in particular, buying or selling a dental practice. In our firm, we deal with a lot of dentists who are either buying or selling a practice. And the reality is they often focus on the sale price and the transition. They rarely focus on the employment issues that can arise. And I've seen people who end up with substantial costs that they never anticipated and never would have agreed to if they'd known. If you have any questions after today's episode, feel free to email us at info@Rudner.ca. Reminder that past episodes can always be found on YouTube, on our website, and archived on Facebook. And if you like our page, subscribe to our channel so you get notifications when all these episodes are live. I do want to note that we are testing LinkedIn, and hopefully this episode will be streaming on LinkedIn and future episodes as well. just a reminder as well to keep in touch with our firm throughout the month, not only once a month for Fireway. Sign up for our newsletter, check out our blog, check out our social media pages. But as I always say, remember that none of that replaces legal advice. So if you think you might need an employment lawyer, you probably do. And I'll extend that to talk about the situation you recently lost your job, as I talked about before. You definitely do. You should go see a lawyer, make sure your rights are protected, and make sure you don't do what I often see, which is people come to me a year later and ask if there's any way they can get out of the place they signed, because they now realize what they gave up. And in most cases, it's too late. So thank you, Rob. Thanks, Rebecca. Thanks to Mark. And again, thank you to Omar. And thanks everyone for tuning in. See you next time.